To our guest out in the, I guess you call this the seating area, the gallery, we have a tracing sheet up here that we need you all to sign in. I think you said is it right there? One's for public comment and the other is the tracing sheet. So thank you.
Senator Brass, how are you, buddy? Glad to be back. Nice mask.
Welcome.
Thank you. Hey, bud, I get paid to wear this. I bet you do.
All right. Well, seeing that we have a few minutes past 8 o'clock, I will call this meeting of the Juvenile Justice Committee to order. Our first order of business this morning is going to be Senate Bill 477. And I just want to point out to the committee and to those who have joined us via Zoom, we do have a couple of presenters. So Senator Kirkpatrick will present this. We have two folks on Zoom who would like to speak to the bill, so we'll recognize them after that. But just for clarification, I don't think anybody's come in, but if you do want to speak for or against the bill, there is a sign-up sheet down here. If you are a non-committee member, there is a committee check-in, sign-in COVID tracing sheet. Senator Brass, we won't make you sign that. So, but with that, if you'll bear with us with Zoom and trying to make everything work, we will move forward accordingly. So, Senator, if you will tell us about Senate Bill 477 and just, if I may, confirm our LC number that we're working off here for you and the committee. I have LC 480204S.
That's correct.
Thank you. The floor is yours.
Can you hear me, folks? Okay. Thank you, Mr. Chair, and thank you for helping me get this important bill moved forward. I'm a physician, so I'm not usually carrying legal type bills, but this one's important to me personally because I serve on the Commission on Family Violence. Family violence investigations by law enforcement can sometimes result in the unintended arrest of a victim. This bill is very simple. It defines the term predominant aggressor and makes it clear that the person who represents the most serious threat is the one to be arrested in a domestic violence call. This bill is supported by the commission, and it should make it easier for law enforcement to train their officers in domestic situations. The bill was unopposed in the Senate. I haven't heard any opposition, and there are many other groups that support the bill, but I won't spend time going through that. I'd be happy to take any questions.
Thank you. You do have a question, Representative Reeves.
Thank you, Mr. Chairman. This is not a question, but this is in my wheelhouse in criminal law area. And the committee should note that this is a Title 17 bill, not a Title 16 bill. Title 17 is criminal procedure. And this does not alter or change criminal offenses, but what it does is it relates to criminal procedure, particularly with how police officers are to investigate. So this is simply a way statutorily how we advise certain investigations and how they come to the conclusions on charges. And I have seen in my 15-year career a lot of examples where there may have been mutual combat, and it was clear that there was that the cause was one, but there was mutual combat involved, and so therefore both parties sometimes get arrested, which essentially makes the case unprosecutable, which is very problematic. This gives the police officers the ability, the discretion to make a determination on, it's more or less a common sense determination. All right, there very well may have been mutual combat here, but it's very clear predominantly where the violence came from. And so I think that this is an overdue need for our law, and I believe it is going to help change the way that police officers can make those investigations. So I wholeheartedly support this and ask that the committee do as well.
Thank you, Representative Reeves. Any other questions before we go to Zoom? Okay. I will. What's your mic number? Go ahead.
Thank you, Mr. Chairman. I would like to know how you envision training the police officers if this bill was to become law, training and education of the police officers for this particular instance.
Most of the training is done at the Public Safety Training Center. The chiefs of police did come and testify in favor of this bill. They really thought that it would make it more clear, because primary is a very vague term, and predominant really helps in clarifying that.
And if I may, Representative Reeves, if you'd like to add to that.
Yeah, I mean, I have a feeling that we're going to get a lot of questions and inquiries on the subject of police training from here to come, even when I think something very, very clearly speaks for itself. But the difference between predominant and primary means the first would mean the first to commit an act of violence. Predominant would mean the one that overall committed the greater act of violence. And sometimes a person can be baited into being the primary aggressor. And I think that it's about as simple as it can get. It gives the police officer, instead of finding who struck first, primary, predominant, much more objective viewpoint of who was the real cause here. So the words mean everything. And I think it's actually a very simple police training to teach them to approach an investigation that way, which is, I believe, the way that, frankly, a lot of police officers approach it today as we speak. It's just not what the word in the law is.
And Representative Reeves and Representative Dickerson as well, I think that our two speakers may be able to add some additional input to that if we could bring them in. I think they are both in that field and will have some valuable input on that.
Can I follow up, please?
Please.
I appreciate that, and I appreciate what Representative Reeves was saying, but there's a lot that speaks for itself, but it doesn't necessarily happen. So I just wanted to ask the question for clarification in terms of the training and the education, because I think it needs to be done. Thank you.
Absolutely. Thank you. We are going to attempt to bring in Stephanie Woodard first. So Ms. Woodard, if you would please introduce yourself to the group, and then when you are done, if you will introduce the speaker following you, and we'll turn it over to her as well.
Thank you so much. Can you hear me? I appreciate the opportunity to stay in my hometown and testify and be with you virtually. Thank you for your service and for you driving in and existing in the new world order there at the Capitol. My prayers and appreciation for your safety, for your health are great at this time. I am incredibly thankful you are willing to consider this bill. It is such, it can present as such a small factor, but it is mighty and meaningful. My name is Stephanie Woodard. I'm the elected Solicitor General in Hall County. I have served previously on the Prosecuting Attorneys Council. I continue to serve as board chair for the Georgia Commission on Family Violence. In both of those capacities, in all of those capacities, I've worked with law enforcement, trained law enforcement as a prosecutor and a commission member. The commission's been keeping statistics on this issue for the last 4 years that I've been involved. What our pre-training and post-training show is that 73% of law enforcement thought that the word primary meant he or she who struck physical violence first. I say that without indictment for law enforcement because the literal meaning of the word primary under Webster's is definition number 1, first, and definition number 4 of greatest import. This bill, this simple change of one word, allows us to follow precedents of almost 24 states that have already made a shift to and allow the officer to contemplate that it is something other than a numerical order of violence. I appreciate both of our representatives' questions and comments. As Chairman Reeves said, this has been an issue throughout time, throughout modern prosecution for family violence. As the representative requested about training, this change allows us to do from a very simple legislative update, news bulletin type, to roll call training, to absolutely weaving it into the commission training procedures, PAC's training procedures, as well as JIPSTIC, the Georgia Department of Public Safety training. This simple word change will save arrests, will save family trauma, will save children from being taken into defects custody. Because as Chairman Reeves said, when 2 arrests happen, it derails a criminal prosecution, but it also often leaves children in the custody of defects in the middle of the most tumultuous situation in many families' lives. I appreciate your consideration. I'm available for any questioning. I'd like to hand the microphone off to Jennifer Waindell. She is a career state and federal prosecutor and subject matter expert on training law enforcement for domestic violence. Thank you.
So I'm going to take control of the microphone momentarily. And just so you know, on Zoom, I either have to have my microphone on or you get your microphone on. But we do have 2 questions, Ms. Woodard, from Zoom, if you would. Representative Thomas, I believe you have a question.
Thank you so much, Chairman. My quick question, and it's crazy because she answered the question as I was asking it, but I just wanted to make clear that I know he said that wasn't a part of the criminal code, it was part of a different code, but this is a very important bill. And I want people to understand, again, to reiterate exactly what was said before, and that this would help when it comes to domestic violence cases and when defects comes in, because a lot of the times, again, when it comes to these abuse cases, it might be the mother might be the aggressor because she was provoked or something happened before. We don't know exactly what happened prior to, and she might have been being abused prior to, but because when the police show up, of course, everyone goes to jail. And so if we can stop this from happening, we can stop the kids from going into care when you have a mother that's been provoked and been abused prior to, and the police they don't have any record of that, of course, but the kids are taken away because both parents are going to jail. So I don't want to, go ahead and make a motion, but I do want to say that I'm heavily in support of this bill. And I thank you all for bringing this bill forward. It's very important in reducing the number of cases that we have in defects. So thank you.
Thank you, Representative Thomas, for your comments. Representative Kendrick.
Thank you, Mr. Chairman and members of the committee. So I'm in support of this bill also. I just wanted to be clear about the legal reason that we need to change. But before saying that, I just hope and pray all members of the committee remember that each member of the legislature has the right to ask questions about bills pertaining to police or whatever subject. So I hope that we can remember that as members of the legislature. But my question is, could you explain again the legal reason why when there that both of the participants would be arrested?
Representative Kendrick, we lost you there for a second. Could you please repeat your question?
My question was, could you explain again the legal reason why the change is needed? Like why were both the mom and the dad being arrested at the same time, and why this change was needed? I support the bill. I just wanted everybody to be clear why we needed the change.
Absolutely.
Representative
Matt.
Reeves.
Yeah, I'll be happy to answer that question. In many, many years of handling these type of cases from both ends, the court system and the prosecutor obviously isn't there to sort out the facts or to sort out the charging decisions that are made at the time of an arrest. That's not their role. Their role is to later consider those after an investigation has happened. And when there is mutual combat, then a lot of times there is a decision is made to go ahead and make two arrests. And whether that should or shouldn't happen, I don't have the answer for that, and none of us can answer that. But changing the analysis, sometimes they can't tell who the primary aggressor is. What typically happens when the police respond to this type of situation, they are told two different versions of the story, and you see physical injuries on both parties, and they are unable to tell who the primary aggressor is. And so a lot of times, in an abundance of caution, there will be an arrest of both parties. And this changes that analysis in law from primary, where it's oftentimes impossible to make an educated decision on who actually was the primary aggressor, to changing the analysis to a more objective analysis of who is the predominant aggressor. And so you can look, those two words are not the same. Those two words are not synonymous. They do not mean the same thing. And I think that this is going to, number one, bring us in line with probably how a lot of police officers across the state are already conducting investigations. And then it's going to solidify and change the official training on that, because we are changing the words in the law to that more objective standard. And so I don't know that's the best I know how to explain it.
Thank you, Representative Reeves. At this time, we're going to go back to Zoom, and we will recognize Ms. Waindell to speak to this as well.
Can everyone hear me okay? Can everyone hear me? Okay.
Yes.
My name is Jennifer Waindell, and I'm an investigator with the DeKalb County District Attorney's Office in their Special Victims Unit. I've been a Georgia Peace Officer for 15 years. I've been a Georgia Post instructor, which teaches at police academies, roll call trainings, inter-department sort of training since 2012. And I've been working in the field of public safety and intimate partner work for 14 years. And I want to thank you all for having me here, Vice Chairman and the rest of the committee members. I really appreciated the comment from everyone that has shared so far. And I will try and keep it brief since there's been a lot of information already shared, and I know your time is valuable in this session. So as someone who trains within my department on domestic violence to other departments in Georgia, and I also train nationally on domestic violence, I can tell you from the baseline of the 8-hour block that I teach at the police academies of the one-day domestic violence training that they get, all the way until a veteran seasoned officer, there is a confusion around the word primary. When our code section was written originally, the term nationally was primary aggressor. That was kind of what everyone had decided on that would be good. But if you read the rest of the code section, it basically reads that it should be identifying the predominant aggressor. But what officers from, I call them the junior rookie officers all the way to the seasoned ones, the first point in that code section is the primary aggressor. So if they get on scene and it may be that the victim possibly struck first today, whether to flee for their own safety or to take their children away, because a victim will generally know their abuser better than anyone. And it could be anything where he or she abuser has left a signal. I've had a case where the abuser would leave a wrench on the nightstand, wouldn't do anything with it yet, but it would be the clue that something would be coming for you later. And at that particular instance, the victim struck first to flee. When law enforcement's called, she technically struck first that day, but he had a criminal history and a very thick packet of lots of domestic violence offenses towards her and the children beforehand. So that's one example. Another example of dual arrests, which since I'm an investigator in a prosecutor's office, I see these cases come in. And sometimes, just like Representative Reeves said, they're unable to determine who struck first because they hinge on the word primary instead of doing the further investigation because it's unclear that they should be identifying the predominant aggressor over time. So what's happened nationally the past 10 years, everything from the International Chiefs of Police Association to Equitas that nationally trains all the prosecutors, to the National Council of Juvenile and Family Court Judges and so on, have tried to push nationally that anyone that has a primary aggressor statute to change to predominant aggressor so that we're not having dual arrest scenarios or having victims arrested by accident, which costs our criminal justice system money. It re-victimizes and re-traumatizes the victim, the children that are left behind that may end up in DFACs or with other family members that may or may not be safe for them. So there's multi-tiers to it. I did want to address the training and education part. I can say because I do the training and the education in that, for example, 1 8-hour block that they get at the Post Academy, we go through the entire code section. We go through all the examples and the ins and outs of it. But what me and there was a Major Eisner that presented in the Senate committee hearing earlier is that we spend an even extra amount of time pulling apart why primary isn't the thing you should hinge on and how you have to do a predominant aggressor inventory. And that's what we as proactive special victims sort of investigators and frontline law enforcement want to make sure that those officers know. Whereas if it was from this year forward that we know that we're going to be investigating the predominant aggressor, it takes that confusion away. It would be a very quick, easy roll call training, 10 to 30 minutes, something that can also be pushed down by a webinar. And then Post will always push down the legislative update every single year. And for officers to recertify their peace officer certification, they're required to take certain blocks. And one of that is a domestic violence update. And it's a 1-hour course that's free, that's pushed down from the Georgia Public Safety Training Center. I don't want to take up too much more of your time, but I'm available for any questions if you have any questions from the peace officer perspective or the trainer perspective.
Thank you very much. I appreciate it. Senator, anything else that you would add?
I wanted to thank my colleague, Senator Strickland, for helping me with this bill because he is a lawyer. And also, words matter in the laws that we pass. And that's the reason that this bill is being brought forward. And I appreciate the commission and the other folks that have testified. And I would ask for your favorable consideration. Thank you.
Thank you very much. At this time, what is the will of the committee? Representative Reeves?
Mr. Chair, I'd like to make a motion to pass.
We have a motion and a second that Senate Bill 477 LC 480204S do pass. Is there any further discussion?
Mr. Chairman.
Go
I
ahead.
just wanted to ask Mrs. Landell, just, when she asked if there were any questions, I did have a question. I love the bill and I would like for it to pass, but just for me, I wanted to know how many police officer, let me see, how many cases resulted in both parties being arrested because the police officer does not know which one was the predominant or primary aggressor? Mrs. Landell, I wanted to ask her that question, if she had any stats on that.
Okay, we're going to turn it over to her at this time.
Thank you for your question. I do not have a specific data point. I'd be happy to follow up with you afterwards, but what I can say in my 14 years of working in intimate partner work and all of it being in the public safety perspective, I do not have a count. It's not overwhelmingly that it's every single case that I have, but for example, within the last 60 days of doing investigations within my current role in my current department, without into specifics in those, I've had 2 to 3 that I've identified that are possible where the wrong party may have been arrested. One was a dual arrest scenario, and one was someone that was certainly the victim over time. And there's a lot of documentation that the other party who's listed as the victim in the report is the true predominant aggressor. But I can't get into specifics on those since those are open investigations, but that's just 2 to 3 within the last 60 days, just from my caseload, which is one person in a very large department.
Going to recognize Representative Reeves.
Thank you, Mr. Chairman. I don't have stats either, but I can tell you whenever it happens, even if it just happens one time, it essentially forbids a prosecution, because if 2 persons that are charged against each other for committing a battery or family violence battery or assault, they both have constitutional rights and the right to not incriminate themselves. And you cannot obtain a conviction without the testimony of, in those cases, both persons are technically the alleged offender and the alleged victim. You can't obtain a conviction against one without the testimony of the other, and they both have the right not to incriminate themselves. So it essentially creates a prohibition. And so again, this is one of those things that if it happens one time, it's too many. And so being able to educate and train our officers to come to the best decision possible is tantamount to everything else in this.
Thank you. Okay, here's how we're going to do this. We have a motion and a second, and seeing no further discussion, in fairness to our representatives on Zoom, we're going to have a roll call vote. So we'll do those members who are here in the room, and then Representative Thomas and Kendrick, I'll open up your microphone and call your name. So down the roll, if you will, just please raise your hand so I don't have to keep putting microphones on. Representative Cantrell. Representative Dickerson. Aye. Representative Lott. Aye. Representative Oliver. Aye. Representative Reeves. Aye. Representative Wertheiser. We will go to Zoom now. And I will not be able to speak, so when I open this up, Representative Kendrick, please cast your vote. Following that, Representative Thomas. The microphones are now yours.
Aye. This is Representative Thomas saying aye.
This is Representative Kendrick, and I vote aye.
Have I missed anybody hiding in a corner? Seeing none, the ayes clearly have it. This bill shall move on. Senator, thank you so much for your time this morning. We appreciate it.
Representative Rich is carrying the bill in the House.
So again, for the committee, you know that Chairman Rich will carry this bill on the House side. I know that others may have to excuse themselves for a meeting, but we do have 2 other pieces of business. So Senator Brass, you have 2 bills before our committee. If you will start with Senate Bill 439. And when you get your copy of that, I will confirm with you that we are working on LC 412341.
Got it, Mr. Chairman.
The floor is yours, Senator.
Thank you, Mr. Chairman. This bill is simple. It came from some foster parents from around the state. It's not a large issue, but it does happen. Current Georgia code, foster parents are supposed to be allowed to be heard in dependency and adjudication hearings, TPR disposition hearings. There are some instances, while few, but it does happen where these foster parents aren't allowed to testify in court. So we worked with the department, we worked with the foster parents, and coming up with just really ensuring that these parents, should they want to be heard, that they are. So what this does simply is it just makes the court in writing make sure that they're recording that the parents either did choose to speak or did not, or chose not to speak. It also requires that in writing that they are notified of when the court hearings will be. So just to kind of break down the bill, to simplify it here, sections 1 and 2 does all this with and the 1 and 2 is your dependency and adjudication hearings. And then section 3 and 4 deals with your TPR and disposition hearings. And then if you look at line 35, as long as the caregiver does agree, it just simply allows that that in writing that we are requiring, it allows it to be by email.
Thank you, Senator. Are there any questions from the committee? Representative Oliver, is that you on 15?
I don't remember seeing a legal notification being delivered by email. Is this based on the new federal statute in any way? I'm curious where this comes from.
Well, it originally came from issues hearing from foster parents. If it'd be okay with you, Representative Oliver, Dr. Tom Rawlings is here, obviously, who is the director of Department of
I
Family
thought we
Children
had
Services.
given notice. Commissioner Rollins can correct my memory as to exactly when we gave foster care parents the right to participate in juvenile court hearings and how they were notified, and how, if this is a change in the law in terms of notification. That's what I'd like to know.
Yes, ma'am. If you recall the old changes to 1511-58, I believe it was, probably back in 2004 or even earlier. Or maybe it could have been in 2007. But the issue, as you may recall, was that we had the agency removing children and placing children in other placements without any notice to anyone.
Right.
And so it was an issue of placement stability.
And the notice was, the initial stages was notice to the court, if I remember correctly.
Right. However, there were also, I think at the same time, it was notice to everyone, including the physical custodian of the child, with the ability of the physical custodian of the child, the guardian ad litem, any party or the physical custodian to file an objection. There was supposed to be 5 days notice, and it could be in writing. The dilemma, and of course, this is not really since the foster parent is not a party, it's not a question of, whether it's a official court notice. The dilemma we ran into, or still run into, is that foster parents are not getting that notice.
Right.
When they do get the notice, they don't know what to do with it. So when I was at the Office of Child Advocate, and even as the director of the agency, I've had situations where foster parents, or even after the fact, they said, "Yeah, we got notice, but we didn't know what to do." And I can't hire, I don't know how to file anything in juvenile court. So this is a part of this. So that particular section is based upon a California law that requires that their equivalent, the Council of Juvenile Court Judges or the court out there, provide a way to file an electronic response to a notice that a child will be moved. And this bill really puts more of an onus upon the court to actually, especially whether it's a hearing from the children, but especially in the situation of a child being removed from a foster home, if anyone is concerned about that move, and they should be, because we have I wouldn't say a lot, too often we have children who need placement stability and may be moved from one placement to another, not necessarily because of policy reasons.
I'm with you on all that.
Right.
We understand all that. what I'm curious about is if you have a statutory entitlement to notice as a foster care parent, a physical custodian, is this the first time in the code that we're setting forth the obligation of a counsel juvenile court judge to define the entitlement to electronic notice of a statutory entitlement?
I believe it probably is. Yes, ma'am.
Yeah, that's a big deal, and I'm not opposed to it. I just want to recognize that this is a fairly significant.
But yes, ma'am, but it is consistent with what I know they've done in other states. And I think the key is that because the practice we've seen, unfortunately, is that the foster parents weren't getting notice. And when they got notice and they had a problem, they had no way, really no practical way to respond. And this allows them an avenue that puts the burden on the court to hear from them and to actually address the issue. That's another issue we've had. We've actually had foster parents who did file objections. There was a hearing scheduled on those objections, and they were never, the court had basically a review hearing in which it didn't even discuss the objection. They just sort of had a status hearing and said, okay, well, everything's fine here. So those foster parents walked away, I think, extremely frustrated, and for good reason.
I'm going to support this bill. I just think it'll be interesting to see what kind of rules the council puts forward. And obviously, you're putting foster care parents in different statuses based on whether or not they have email or don't have email. I don't know if the rules, I don't think the statute or the rules says, please correct me if I'm wrong, how foster care parents are notified now.
And Representative, I'm certainly I admit, no lawyer, but I do understand where you're coming from and to the director, but I do see here on line 36, party who will receive the notification has agreed to receive via email, and on the line before, we include the word may rather than shall.
That's
So-
correct. Thank
so-
you.
And then you look at line 50 where the council's going to flesh that out in some kind of rule. So I'll be interested to see
Right.
what the council does in that rule.
Thank you,
Yes, ma'am.
Representative.
I think the key is for them to create a form for it. So,
And-
yes, ma'am, it will be interesting, but I think that anything we can do will be helpful.
Representative Reeves.
Thank you. Not a question, but a comment to my colleagues. This is an important bill. Having done work in juvenile court proceedings, as everybody on this committee is well aware, is very different than other court proceedings. And this is all about allowing the judge in a juvenile court setting, who has to make some of the most gut-wrenching and difficult decisions that are made in all of the law in our country. It allows them access to as much information and perspective as possible before they make those decisions. And it's not just important at that, but it's also important when those decisions are appealed, and the Court of Appeals has criteria in Georgia law that it has to point back to on those decisions. And sometimes decisions where everybody in the room 100% would agree the right decision is made, but the Court of Appeals has to reverse a case because of the way the law is. And I believe that this is an effort that gets us closer to better justice in those decisions being made, and it gives the judges more relevant criteria to consider. This is an extremely important piece of legislation, and I'm very, very thankful for the senator for bringing this.
Thank you.
Momentarily. Okay. Representative Oliver, your number again, I'm sorry.
You might want to comment too for me or others. Beginning on line 97, you're asking the court to make specific findings in relation to notice. Does this come out of a case? You're trying to correct a case on this, or?
No, ma'am. This is, again, generally, as Representative Reeves alluded to, a question of findings of fact on issues. While we have recognized in our code from, I think, many years now, the right of foster parents to notice, and it doesn't have to be legally sufficient notice since they're not parties, and the right to be heard, there is nothing in the code that actually, if you're going to write a full order it would be helpful to have information in that order about who spoke up and who said what and what kind of information was provided. And so what happens is I think my friend Jerry Bruce would say, what happens is even if they get notice, and even if they have an opportunity to be heard, there's never any indication of whether or not the court actually heard them. And so this helps us also with documenting, as Representative Reeves says, what's going on with the family, because the foster parent is often the most knowledgeable folks about what is currently happening with the child's well-being. It helps create much more fleshed out orders, including, of course, status review orders and case plans and that kind of thing. And so we're just making sure that the courts take the legislative direction to hear from foster parents, which of course is a right of foster parents, and make sure that that's actually included in what the court's considering, and the court has determined whether or not what is heard.
May I ask one final? Look at 124, line 124.
124.
124.
Okay.
You seem to directing the court to make a specific finding of fact based on the length of time that a foster child has been with a foster care parent. Is that reference there to that length of time set forth anyplace else in the code, or is that a new definition of entitlement to court attention?
Yes, ma'am. This does expand a little bit on the TPR matter. This is actually based upon a couple of other state statutes I found around the country. The idea, of course, is that if you have a foster parent, and of course this is just in the dispositional type hearing, so this is this has nothing to do with the determination of whether a parent is fit or unfit. This is after the court has already determined that the parent's rights should be terminated. That if you have a foster parent of or relative caregiver, anybody who's had the child for a significant period of time, for up to a year, or at least 12 months over 12 months during the most recent period, that and if they are willing to adopt the child, that we need to consider evidence on that particular issue.
Thank you.
Representative Dickerson, did you still have a question? And if you could, 23.
Thank you, Mr. Chairman, and I'd like to thank Dr. Rollins for all of his expert information. And I would like to say also that all bills are important that protect our children, because our children are our most valuable assets. I would like to know, will the state have employed the services of outside workers in order to staff the parent training program?
I apologize, I missed the question.
Will the state have to employ outside services in order to staff the parent training program?
Representative Dickerson, I guess what it means by in terms of the parent training program, in terms of.
For foster parents, yes.
I think that's on the next.
Oh, it's the next one? Oh, I just got the wrong bill.
No worries.
I'll be if you hold the question, I'll be happy to address it.
Seeing no other questions from the committee, what is the will of the committee? Representative Reeves?
Mr. Chairman, I'd like to make a motion do pass.
We have a motion by Representative Reeves, a second by Representative Oliver, that Senate Bill 439 LC 412341 do pass. Is there any further discussion? Seeing none, once again, we will call the roll. For those here in attendance, those voting in favor will vote aye. Those opposed will vote no. And Representative Cantrell. That is aye. Representative Dickerson. That is an aye. Representative Gravely. That is an aye. Representative Gullett. That is an aye. Representative Oliver. Representative Lott. That is an aye. Representative Reeves. That is an aye. Representative Wertheiser. Representative Blackman, is that you in the corner? And your vote? That is an aye. We will now go to Zoom, and Representative Kendrick, if you will vote, followed by Representative Thomas.
Representative Kendrick is an aye.
Representative Thomas is an aye.
At this point, the ayes clearly have it. Is there anyone present that I missed for a vote? Motion carries. Thank you, Senator. Let me explain on the next bill that Senator Brass is going to present. There is a committee substitute. You should have it on your desk. Senate Bill 335, LC 500087S. If that is not what you have on your desk, please let me know and you can utilize my copy. Here's how we're going to do this. Senator Brass is going to present the bill, and then I'm going to explain the substitute language. And if you'll bear with us just a second, we're going to grab these copies to anyone that needs them. Again, LC 500087S. LC 500087S to Senate Bill 335. You can use mine for the time being.
Can we get an image of the substitute?
Senator, the
Zoom?
floor is yours.
Thank you, Mr. Chairman. I'll give a brief overview of the underlying bill, and then, take questions or so. So Section 1 is simply giving foster parents a free admission into our state parks. Just a small gesture from the state to say thank you for taking care of these kids and giving them a loving home to live in. And we did kind of work with, we worked with DNR on that, and they'll come up kind of with their own system. And so we left that language fairly vague so that they could in fact, we even had to tweak it a little bit to make it more vague so that they could come up with their own system. So you'll see that in lines 22 through 26. Skipping ahead to Section 3, on lines 85 through 90. This simply puts in a tracking system on these cases all cases that are dealing with foster children. As we know, our courts can get a little backed up at times. Most juvenile courts are doing a great job, and I'd even say all of them are doing a great job most of the time. But every once in a while, there's lack of resources or just case overloads, and we really haven't tracked. We don't know where the problems are, and if you don't know where the problems are, you don't really know how to address them. So this just kind of helps put in a little bit of a tracking system so that we can keep a better idea of how long these cases are taking in different courts. Then skipping ahead to Section 4, which I believe is lines 97 through 100. This gives our hearings with dependency cases priority over all non-jury trials. We've heard from multiple courts that we've got attorneys, most of the time private attorneys are hired, and they have, higher paying cases elsewhere. And a lot of these cases get delayed. And so, we feel like they should be a priority. These children and are going through some traumatic times, and the more we delay, the more that they have to come back to a court and rehash this. It's just causes more issues, and so it simply does give them priority. Section 5, in lines 121 through 123, and also in 147 through 149. This simply gives the department the ability to contract with child placement agencies and casework service agencies. We feel like even now, although this bill was done before the suspension of the legislature, and the economic crash that we're facing and the budget shortfalls, we feel like this is even more important than it was back then. But it just simply gives the department a little bit more flexibility on being able to, essentially bring in third parties. Also in section 5, lines 231 through 235, this gives the department more flexibility on offering varying levels of training hours for both our respite families and our experienced foster families. We know right now there's a certain amount of training hours that foster families have to do each year, no matter how long they've been doing it, no matter how many kids have come through their home. And that same amount of training hours is required for our respite families. So we want to give the department the ability, especially in our respite families. I mean, to me, this is almost a great recruiting ground for more foster families. And as we all know, we have more foster children than we do foster homes, and it's tough to find placement. And so if we can recruit more people, and just, respites kind of, you come in, you give temporary relief for these foster families. If we can get more into that system, we feel like it could be a feeder program into our foster families. And then also for our, on the complete opposite end of it, you've got these foster families that have they've been doing it, maybe 20 years, and might have, they might do five kids a year, whatever. And the department has no flexibility. They're having to do the exact same amount of training, and kind of training. And so this allows the department to kind of tailor maybe a different type of training depending on the type of child that may be, and the different needs of that child that may be coming to that foster family. So it just gives the department more flexibility in those regards. So with that, I'll be more than happy to take questions.
You do have a few questions, and I'll try to get to them in the order they were asked. Representative Reeves.
Thank you, Mr. Chairman. And not a question, but a comment for the committee. And I thank you to Senator Brass. This is all the way around this building, from the governor's office to the lieutenant governor's office to the speaker's office, there is a great appetite to work together to improve the efficiencies of our foster care system and DFACS. And it's something that we've talked about, and action is now taking place. The provisions of this bill are extremely important. In fact, they've also been added to one of the bills that I'm carrying. We're making sure we get this across the finish line, no matter who carries it. But these will create efficiencies. And I wanted to make the committee aware, with the conflict provision, which is section 4, it's not just attorneys that are paid more on certain cases. The rules of the court sometimes require, you may have a very important dependency hearing set in juvenile court, and you also may have a criminal case happening at the same time where nothing is going to happen. But the way the rules of the court are set is that you're required to make an appearance first on that criminal case, or even in certain civil cases. And that would and sometimes you sit there all day. And what happens is everybody is ready on this dependency hearing. Everybody is ready to move forward. Everybody is ready to get it done. But because of the way that the rules of the court go, the lawyer can't show up. And so what happens? We have to continue everything and get ready again. This changes that conflict order to create priority there. Extremely important change in our law that is going to help with the efficiency that we have been so committed to trying to bring to this part of our law. Thank you.
Representative Cantrell.
Thank you, Mr. Chairman. Senator Brass, line 235. I know this bill was written pre-pandemic. I'm wondering why we chose may be offered online. In light of current circumstances, would we consider that being a shall?
I think you're probably going to run into some federal requirements there where it wouldn't be allowed. And so we put may, and I think wherever it makes sense, the department will be able to do it, and where it's not allowed by federal code,
So you're
we're
saying,
not
I'm
tied in
sorry,
there.
follow up.
Sure, and Director Rawlings may want to
Right.
interject here
So
as well.
so there's federal code that prevents some of this training being
there's
done
some-
online?
There's some standardized stuff that's, if I recall correctly, I need to check with my policy people, but some things have to be done a little bit in person. But we've gone to a lot of online training. We're going that way. And I think the key is that we've probably got to balance some of our in-person training with some of our online training, but especially with regard to the respite care training, which
Right.
is what we're really dealing with here. I think the key there, I don't think we're so much focused on the, online, in person. We certainly want to make it as easy as possible. The key, of course, is that, at least for us, the policy key was that we were having to do the same amount of training for a respite care provider
Right.
as a full-time
I
foster
get that,
care.
yeah.
And so, I appreciate your fly specking that, so to speak, your detail on that. I hadn't really thought about the detail of may or shall we intend to do things online as we're going forward.
As much as possible. Yeah, thank you.
Okay. Representative Oliver.
Direct your attention, please, to line 85, and Commissioner Rollins may want to help on this too. This looks like it's focused only on the crossover children, and I'm curious about how this is worded. You're talking about rules adopted by the Supreme Court after January 1st, 2021. Are the clerks not giving you information you've requested on crossover children at this point? Or am I totally off base and this isn't about crossover children?
This is about crossover children, yes, ma'am. So what we are kind of go back, and I apologize for not remembering the entire history of creating this particular part of the code section, but I do recall and of course, I think as many of us, we're not sure whatever happened before April or March 16th of 2020. As many of you know, we have a lot of children who come in, not a lot, we have, I think, a significant, but small, but very significant population of children who come into our foster care system via delinquency issues.
And you're required federal law to coordinate that. You have federal requirements in relation to the children that are jointly in two different agencies of the court. But I'm just curious where this came from and why you need it at this time.
Because we really do need to better track from the courts which children are coming. Unfortunately, our system has not really been set up very well to track which one's coming in because the child has mental health needs or developmental disability needs, or because they're delinquent and they've been discharged from the YDC and the parents refused to pick them up, or they were at a crisis stabilization unit. They have behavioral issues. And so if we can better as a state track those situations, because in every situation like that, there is a court giving us custody of that child. And if we can better track those cases, we can also better develop those multidisciplinary cross-agency systems needed to.
You're obligated to track them. I understand that.
Right. But we as an agency could do our best to track them, but it would certainly be better if we can have more of a coordinated statewide court system to do that too.
Mr. Chairman, can I have one follow-up? You
Sure.
have two references to authority to basically privatize some child placing services. I'm just curious why you need that legally. It's on 121 and it's on 148. I couldn't figure out to myself why you needed that specific legal authority, since you do it in so many other cases.
Yes, ma'am. I think it just clarifies to the extent that the law needing clarification is, as you well know, Representative Oliver, we contract, I signed yesterday about 2 weeks worth of contracts with private agencies, with child placement agencies, with wraparound services, with educational folks, all sorts of things that so I would say that, as you know, about a third of the children in foster care are placed with private child placement agencies. And I think the key is just to make sure our legislation reflects our practice as well, that we are in fact, asking our child placement agencies especially to do casework for us. And I think the longer term thing we're looking at is how do we make sure we're using those casework services in the most efficient way possible, so that we're not duplicating what's a DFACS caseworker is doing with what, for example, a Methodist Children's Home foster care caseworker is doing.
Thank you, Mr. Chairman.
Thank you, Representative Oliver. And last question, and again, Representative Thomas, I'm going to recognize you via Zoom, and you will have the microphone and we will be off. So the floor is yours.
Okay, thank you. Thank you so much. So this question is probably best answered by Commissioner Rollins. I have how many hours is a foster parent supposed to have in training per year?
Well, Representative Thomas, you got me on that one. I think the original training is 40 hours, and then I want to say it's 8 hours a year. But Representative Thomas, I have an expert on that, Ms. Tammy Reed, who knows every detail of our foster care training, including the fact that we recently went to we were piloted and are considered a national leader with our new foster care training program. But if I might get back to you on that, I'd appreciate it.
Representative Thomas, if that's good with you, we'll ask Director Rawlings to get with you on that.
Okay, I have a follow-up to that. Can you hear me? So my follow-up to that is that if it is just 8 hours a year, I have talked with, and even with that being said, I've talked with foster parents. I've talked with parents that want to be foster parents. And I've also talked with a lot of the agencies that you all outreach to do these workshops that they do every year, which I think are very important. And I haven't heard from any foster parents or ones that want to be foster parents that the determination of them being a foster parent is hinging upon the hours of them having to be trained. And so 8 hours a year is not a lot of hours if that is the case. Even if it's 20 hours a year, that is not a lot of hours. And a lot of these trainings they can do within one weekend, they can do within one day. And a lot of people like these trainings because they learn different things. There's not just the standard thing they do every single year. They have different workshops a lot at some of these trainings where they learn different technologies and things that they can do for the children. Being a foster kid myself, as you know, Commissioner Rollins, I just do not think that trainings need to be lessened. So I agree with the premise of the bill and a lot of different statutes that are in the bill when it comes to foster children, but this part I would have to be a no on, and I would even try to offer an amendment to take this part out because I don't want this bill to be hinged upon one small part that I don't agree on, and I've talked to a lot of different foster parents and future foster parents, they don't agree on as well.
Well, Representative Thomas, thank you, and that's thank you for your homework, and I know you truly care about this issue just like I do. So I do commend you for doing your homework on this. But I've heard from some foster parents as well, and some of them it is a little bit of an issue. So, but the idea behind that area is more geared towards the respite. Again, as I stated in my opening comments, that the respite families, having to do, I think the director said 40 hours. For some reason, I had in my head it was 100 hours the first year, but that
It may be.
but anyway, whatever it is, for a respite family to be doing that many, be required to do that many, is just going to deter them from entering into the program. And again, the idea is to, feed these families, let them kind of get a taste for it, let them, let's open up their hearts, get them into the program, and then feed them right into foster families, because the ultimate goal is to lead to more adoptions. And if we can get more families involved, I think that's really the idea behind the whole thing.
All right, 2 other quick questions, and then I'm going to explain the final piece of this. Representative Cantrell.
Yes, with much respect to Representative Thomas, I would just say that our church has a ton of foster families, and this is a major issue with those that drop out, is the ongoing amount of training. Because if you work with foster families, most of them already have other kids. They're very busy people, and they're really good at what they do. And then we keep adding these requirements every year. So I think it is a big issue, And I very much appreciate the fact that you're addressing it, Senator Brass.
Thank you, Representative Reeves.
Thank you, Mr. Chairman. This is a question for Director Rawlings. If a foster parent, let's just say the number is 40 hours a year of training, if that's the current requirement by the state, if a foster parent requests or has a need to have additional education and training in order to become a better foster parent or to attain a different skill set, are there resources across the state that they can access? Meaning that if we left it with the discretion of DFACS to determine what the minimum is for any foster parent out there that is seeking a more depth training, that they would have the ability to access that kind of information?
Yes, we work very closely with the Georgia State University Child Welfare Training Consortium. They have all sorts of additional continuing education things. The Committee on Justice for Children, for example, does a lot of training around the rights of foster parents. I know Jerry Bruce goes out and trains foster parents. The local foster parent associations will have, will bring in a speaker to talk about a particular issue. For example, how to foster a child with significant mental health needs. And so there's lots of additional training that can be done. But to repeat Senator Matlock, I just want to note that, this, as he said, it really, the change here really does go to the respite parent. And like him, we're trying to build in a tiered system. We have this, we kind of realized over the last couple of years that the best way to attract foster parents is first you get folks maybe from your church or your community involved in helping out a foster family, and they realize what good work is going on. And then you get them to babysit for maybe up to 72 hours for a foster child. And then maybe they'll say, well, I'll do some training, I'll become a respite foster parent. And and as they become more interested in it, they want to go deeper. So it creates more of a tiered system. And that way, I think we're able to better recruit. Foster parents will stick with us for the long term, and foster parents who will want to go deeper and may even want to become those specialized foster parents with very specialized training in assisting children with severe needs.
So I'm not cross-examining you, but would you agree with me that if you were going to vote no for this bill because your fear is that it would disable or not allow a foster parent to get the kind of adequate training that they want, that would not be a real reason to vote no?
I would no, I don't. I think we have very, especially for our regular foster parents, we have extremely robust training. We have, I think, like I said, our model right now is a national model. It's a national standard model. But I think what a no vote would limit our ability to get those folks who may not be able to commit to being a full-time foster parent, but who do want to volunteer some of their time to be a respite foster parent.
Thank you.
Thank you. We have one last question. We're going to go to Zoom. We recognize Representative Thomas.
I just want to follow up on that, especially with the pertaining to the not voting no, but we've been throwing around a lot of numbers, and I heard a couple of people say, oh, well, it's 40 hours a year. Maybe it's 40. I'm sorry, I just got cut off here. And who wants to do 40 hours a year? But just what Commissioner Rollins just said, it's 40 hours when you first come a year. So, I mean, again, if 8 parent, then to me, in my eyes, you shouldn't be a foster parent if you cannot do 8 hours a year towards enriching and helping towards that foster child. So that's my pertainment. And I also will put it on the senator to, if you are presenting a bill where you're trying to cut the hours down, and you yourself don't even know how many hours that we're even cutting down. So that just kind of makes me eerie about the research of this part of the bill. So we can talk about, who wants to have hours, who doesn't, but we don't hear telling us are. So we're saying, let's cut this something in half, cutting in half. One of the real reasons, in addition to foster parents, but biggest thing for me at this point, we're having
can hear me. We couldn't really understand much of that, but I will say you and I have spoke in the past on this. I do understand your concerns with that part of the bill. And, again, we're just giving them, the department, the ability. We're not necessarily saying they are going to do it. I do know where your heart is on this issue, and I know it's in the right place. And outside of that, I really have no idea what you just said.
That's okay. Representative Thomas, unfortunately, we lost the audio there.
Can you hear me? Can you hear
In
me?
the
Can you hear
interest
me
of
now?
time, I want to explain the reason for the substitute. And if anyone doesn't have a copy of the substitute in front of them, I'm happy to share my copy, or you come with me. Lines 38 and 39 add language related to the Lake Lanier Islands Development Authority. And I know everyone is going to sit here and look at me and ask, why is the Lake Lanier Development Authority on a foster care bill? We have attached this to Senator Brass's bill. It is germane to the code. And due to the late request for the need, this bill was the only vehicle left to travel legislatively. And I want to explain. There's a gap in the leases between the state lease with the federal government and the state lease with the lessee. They should mirror one another, but there is a gap. And since state bonds have been allocated and spent over the years and will be in the future, bond underwriters have asked for the two leases to mirror each other and to remove the gap. Where did the error come from? We believe it was simple human error 15 years ago when this legislation was drafted. Lake Lanier Development Authority and Jekyll Island Authority should have their code authorization extended to mirror. And a few years ago, this body made the same change for the Jekyll Island Authority that we are requesting here. This has been approved and vetted by the DNR, the Speaker's office, the Lieutenant Governor's office, the Governor's office, and of course, the author of the bill. So I'm happy to entertain any questions on those, but wanted to give explanation as to why those are there. Representative Thomas, we're going to try one more time. We're going to try one more time. Representative Thomas.
It's magic.
And God said, knock and you shall find. Why don't you pick a microphone?
The biggest thing for me, of course, I love the premise of the bill, everything else except for the hours. I'm even okay with maybe making an amendment, at least until we can actually know the set of hours. So it kind of bothers me that we're cutting something in half, or we're cutting down something that Commissioner Rollins doesn't know, or, Senator Brass, doesn't really know the hours. So it makes me feel nervous.
The annual hours are 15 hours after you do that initial training, which we still don't know.
Okay.
After you do that initial training is 15 hours per year, 5 of which is mandatory in person.
Okay. So with that being said, 5 of which that's mandatory in person, right?
Mm-hmm.
And if it's 15, you can do 10 online or however that is. Mm-hmm. So we're cutting down initially 5 mandatory hours in person.
You're assuming they're going to cut it down, but it's just giving them the ability to adjust the hours. Yes, they have the ability. We are giving them the ability to take it down. If a foster family has been doing the same training for 20 years, I guess you have to ask yourself the question: should they be doing the same training, the same amount of training, for if they've been doing it for 20 years as a first year family? that's doing the exact same training. At some point, it becomes that redundancy becomes a little bit of a deterrent. And I have heard from foster parents on that. I know you've done your homework, and it's not a problem to most of your folks. But when you get out into some of these rural areas where foster families are actually having to drive in town, in some cases several hours to get this training, it's a lot more of a deterrent than someone, say, in downtown Atlanta that may have to drive 10, 15 minutes or has the ability to hop on mass transit and get to where they're going. It may not be as big of an issue there, but once you get outside of these major metropolitan areas, it does become a little bit of a deterrent. And not only that, but also, as I earlier stated, it becomes redundant when you've been doing the same training over and over and over. We don't want the department to change the quality of training. You and I, as we discussed on the Senate floor the day I presented this bill, the training is very important. There's no question about it. But at some point, when you got it, and you may need to adjust the training. If someone's had 15 hours in just basic stuff for, say, 20 years, and now all of a sudden they have an autistic child, they might be better served rather than doing 15 hours on that basic stuff, go do 10 hours on special needs of that child. And that's the department doesn't have the ability to do that right now.
Well, let me just say this, and I'm not going to prolong it. This is my last point. And Commissioner Rollins, I'm pretty sure he knows this as well, that with those hours of training, usually how it is there's a workshop. Okay. And there's different places where they can go. So it's not just like if you have house member training, the same rules training that you're getting every single year, they can opt to go to this part of the workshop. They can opt to learn more about technology. They can opt to learn about more, kids, because my thing is, even if you have 5 different kids, you have 5 different types of children. So you might get a kid this year that has autism, and you can go into that kind of training at that workshop. Or you might have a kid this year that has abusive issues. And so you might need that training that you didn't need last year, or that you might have forgot about last year. You might be able to go into that workshop and say, I opt to go in there. So it's not, usually just a training where it's just standard. They have different workshops and different things where you can opt in to go. And so again, I'm going to let it go, but 5 hours of in-person training is not that a lot. And a lot of these agencies even offer babysitting. They even offer, things for kids to be able to get babysitting for their other children when they come. So it's a lot of different things that they do at that training, even for the children. So I think that, again, we need to keep those 5 hours, or even just 15 hours, 5 hours in person. We need to keep it like it is. And I don't think that we need to be cutting it down or, tearing it down, even if it's just a respite weekend parent. I think 5 hours is really not that much. So thank you.
Representative
We'll
Reeves.
agree to disagree, but on that part, but that's fair.
Representative Reeves,
I'd
you're
like to make
recognized for a motion.
I'd like to make a motion do pass.
There's a motion and a second. Turn back. That Senate Bill 335 LC 500087S do pass. I do not believe any members are still with us via Zoom. So all those in favor, please say aye.
Aye.
Any opposed, no. The ayes clearly have it. The motion carries. And if I'm correct, Senator, Representative Wiedauer will be carrying both the bills you presented today. Is that correct?
Yes, sir. That is correct. Thank you, Mr. Chairman.
Okay. Thank you very much. This meeting is adjourned.